Good afternoon, committee. Representative Wheeler, would you tell me whether you can hear me or not?
I can hear you, Mr. Chairman.
Excellent. Thank you so much. We'll go ahead and call the Thursday afternoon meeting of the Corrections and Juvenile Justice Committee to order. We'll inquire first of whether or not there are any bill introduction requests from members of the committee. I don't see any hands being raised or hear anybody. Are there any bill introduction requests from anyone else who may be participating in the meeting today, either in person or via internet? I don't hear or see anyone. We will then move on, and I will open the hearing on House Bill 2081, call upon Natalie Scott, Assistant Revisor, to provide us some insight into what this bill will do.
Mr. Chairman, House Bill 2081 would modify how certain prior convictions are counted for special sentencing rules related to possession of a controlled substance. And manufacture of a controlled substance. And then it would also provide for concurrent or consecutive sentencing for persons convicted of new crimes while on release for a felony. So Section 1 amends KSA 216606. Current law there in subsection D provides that if a person is convicted of a new crime while they are on release for a felony, then that new crime sentence has to be served consecutively with the original sentence. And this bill would allow that sentence for the new crime to either be served consecutively or concurrently, however the judge directs in that particular case. And then Section 2 amends KSA 216805 to amend the special sentencing rules in subsection E related to manufacturing of a controlled substance, and in subsection F related to possession of a controlled substance. So the current law in both of those rules leads in with the sentence for a second or subsequent conviction, let me see what that one actually. Yeah, for a second or subsequent conviction. And so this bill would change that language to apply those special rules when the person being sentenced has two or more priors. So it's not the second or subsequent. I will point out, and I'm sure that Scott will point this out as well, I believe I made a drafting error in this particular bill. If you look down in, let's see, it starts on page 6 in your bill. In E, I struck the second or subsequent conviction. And then later I said when such person has two or more prior felonies. So that needs to be one or more prior felonies. So the intent here is not to change the substance, it's just to change how those are calculated. And I can take any questions.
Thanks, Natalie. Committee, any questions for the revisor? See none in the committee room. See no hands raised. Very well. We will move on then with proponent testimony. Call upon Scott Schultz, Executive Director of the Kansas Sentencing Commission. Welcome, Mr. Schultz.
Chair, members of the committee, good afternoon. Can you hear me okay?
Yes, we can.
Thank you, Mr. Chair. This is a technical bill that I'm going to try my best to, I guess, technical times requires technical desperate measures, but I'm going to try and go through this as best I can to try and chunk it up for everyone because for those not practicing in this area on a regular basis, it certainly can be confusing. And so I'm going to kind of go one by one and hopefully certainly be subject to questions afterwards, but hopefully this will be able to, if we can split these up, it may be a little bit more helpful to you, and I hope it is. So this particular, again, these are for the most part, to some degree, technical amendments that the Sentencing Commission is recommending to you for passage. It deals with special sentencing rules, and just as a general information, we have, I've discussed with you previously that we have a non-drug grid and a drug grid. The fundamental ways that we look at offenders are two fundamental things, and that is, what is the severity level of the crime? What is the criminal history of the individual? And so the legislature is deemed fit in setting up the guidelines to indicate, based upon the severity level, you're going to potentially be subject to more prison time. If you have a higher criminal history, and that you're going to be doing more time as well. And so it's a logical situation that I would be treating, or a judge would be treating someone sentencing folks for the same crime that have different criminal histories differently, because the one with the greater criminal history is going to get a harsher sentence than the other one. Similarly here, there are carve-outs that occur in some cases with regard to the guidelines. And so there are certain circumstances where sentencing occurs, and because of certain things, a sentencing rule is sort of an exception to what the general rule is. And so these particular sentencing rules that I'm going to discuss, number 10, number 12, and number 26, fall kind of within this realm in terms of their carve-outs under certain circumstances. So the first one is Special Rule 10, and it has to do with when the court has a multiple sentence situation, when you have multiple cases, and it guides the court into determining, what do I do when I have certain circumstances. And so I'm going to pull up the bill itself, and hopefully this will be able to be helpful for you. So we have the bill 2081 here. There are certain circumstances in multiple sentencing situations that the court can do, and I've highlighted these applicable ones just to kind of give you an idea for what happens when something else has happened, or the individual's already on supervision and something of that nature. So subsection B, for example, if the individual's on probation, community corrections, parole, conditional release for a misdemeanor, then the court can actually run that new sentence concurrently or consecutively with whatever they were actually sentenced to previously on the other case. Subsection C talks about if they're on probation, similarly for a felony. Things get a little tougher here, because now the court is required to run those sentences consecutive to one another. And you know, it makes sense. You know, if an individual's on the felony probation or felony parole and they commit a new crime, then the legislature has said those sentences need to run consecutive to each other. I'm going to skip D for just a second, since that's our relevant one. But subsection E also accounts for what happens when an individual is incarcerated and serving a sentence for a felony. The court is required to make those sentences run consecutively. So what we're talking about today is, excuse me, in a situation where an individual is out on felony bond. And we are proposing that currently the law provides that it run consecutively, and the court is required to do that. However, we're proposing that the court have exercised judicial discretion and be able to do that. Folks that are on felony bond, as all of you know, are on bond, they're presumed innocent, and have not been convicted yet. So we don't believe it rises to the level of what you would have here as far as being on probation and requiring consecutive sentences. So that is the request as far as Special Rule 10. As you will note in my testimony, as far as the data is concerned, that is it bears out that there is some confusion as to that the court actually has to run those sentences consecutive. And so, in fact, only 6 of 10 offenders actually convicted of the crime while they're on bond receive true consecutive sentences. Others obviously are receiving even concurrent sentences. So we believe that this would allow the court to, based upon the facts of each case, to allow the court to still be able to run those consecutive if warranted, but also then run those concurrent if that particular situation is warranted too. As it relates to special rules, the next ones are Special Rule 12 and 26. This is in Section 2 of the bill, and I've highlighted those for you, and I just ask you to look again on the as to the bill that I've highlighted. These 2 bills are based upon repeat drug offenses, and all that the Commission is proposing here is to clarify and articulate what should be happening already, and that this should be reserved for repeat offenses. As you know, and as I explained at the beginning of my presentation, this is criminal history is already taken into account as far as punishment for an offender. So if they have 3 non-person felonies, that's going to be already factored into the mix. The special rule that would apply is an enhancement, and most of the time the enhancements specifically call for presumptive prison. So even if they fall in the presumptive probation range on the sentencing grid, with these special rules applied, then they would be in the presumptive prison sanction. So the first one deals with unlawful manufacture of controlled substance. And as Natalie indicated, and this was this certainly was my fault when this was being drafted, not hers, that this particular item here, so that it reads similar, should be 1 in line 35, should be 1 or more prior felony convictions for a violation. So again, we're not changing, we're not adding 2 things or requiring more convictions for things to happen. What we're actually doing is we're truly clarifying that to require prior convictions. Now, for this particular one, manufacture is rarely used. As I indicated in my written testimony, in FY19 we had one in which this special rule was applied throughout the entire state, mainly because it's a lot cheaper just to get it and distribute it than it is to manufacture it at this point. And so the cost of doing business is much easier to just simply distribute it than actually manufacture. Going further, this would require, of course, a prior manufacturer, and you would have to have a second manufacturer for it to actually apply. And this one in particular actually provides for a pretty stiff sentence in terms of in that the court, if it's methamphetamine, can actually give a presumptive prison sentence up to 2 times the maximum duration of the presumptive term of imprisonment. So it is truly an enhancement. Again, not used that much, but again, the language that we're proposing, we think would actually clarify that you actually have to have prior, at least 1 or more prior felony convictions for that to actually occur. Moving on to special sentencing rule number 26. This is one that many of you are familiar with as well. This is a 3rd felony conviction for possession of controlled substances. Once that special rule is applied, it's presumptive prison as well. Again, simply trying to utilize the language that 2 or more prior felony convictions for the crime would actually constitute that 3rd conviction. So I hope that you were able to get Amanda Both's, the Assistant McPherson County Attorney's testimony. I had the chance to briefly to look over it, and she was actually the one that brought this to the Sentencing Commission's attention through our staff attorney, and the commission then considered it and then is bringing it forward to you as well. And so she was in support of trying to clarify things again in terms of that the individual has to have prior convictions for this to actually be an enhancement. Some of these things that she's indicated in her testimony as well, I think are duly applicable, especially in a situation where you would have charged the defendant with 3 felony possession charges in one case, and the court would necessarily use the first 2 as prior convictions, that then the third one would require prison. And we don't believe that that's what the intent of the guidelines are, and that it's not the intent of the legislature to be counting those in the current case. One of the things that I did in my testimony, prior convictions is actually, and the reason why, it's like, why are we doing this? Prior convictions are actually a term of art within the sentencing guidelines. And it's specifically defined as any conviction other than another count in the current case. And then it goes on, if there's other cases, there's other circumstances. But so you would have to have a prior case in which you were convicted that would allow then for that to be counted to enhance the offense. Again, as I indicated in the testimony, as far as Special Rule 26 is concerned, 288 offenders in FY8 or FY19 were the special rule was applied, and once again, even though as the statute specifically calls for presumptive prison, 7 out of 10 offenders actually were sentenced to probation. So again, the data indicates to us that there's confusion here. And now, keep in mind, there is a presumption that attaches, and sometimes, and as in this situation, the court is signaling that they don't want to send these individuals to prison. But it is interesting to note that, again, 7 out of 10, even though the special rule is applied, are actually receiving probation. So with that, I hope that was was understandable, even though, again, this is a pretty technical area for as far as sentencing law is concerned. But I'm hopeful that I was able to cover the whys of the reason and the rationale of why we're proposing this to you for favorable passage. Mr. Chair, with that, I'd stand for questions at the appropriate time.
Scott, I'm going to have a couple here, and really it's out of respect for new members of the committee and perhaps others who have not had a lot of exposure to some of the more technical aspects of the criminal code, particularly sentencing. I wonder if you would be willing to explain the real effect and difference between concurrent and consecutive sentencing. What does that really mean to the offender?
Mr. Chair, that's a great question, and I should have kind of at the outset. Sometimes people get those terms mixed up, and understandably, if a individual receives concurrent sentences, that means that the court is actually running them together. So if I have a 24-month sentence, and in another case I have another 24-month sentence, and the court orders those concurrently, I will serve 24 months. If they are run consecutive, they are actually ran one right after the other. So in essence, they will serve their first sentence, and then they'll serve another 24 months, and in this case, in this example, 48 months. So there are caps that are placed on that with the guidelines, but from a generally speaking, that is the difference between concurrent sentencing and consecutive sentences. And again, One of the main things that we're looking at is the judges know the cases. They have the opportunity to look based upon a case-by-case situation and determine whether or not this offender needs to have consecutive sentences, or that the court that justice would be served by running those concurrently with each other. And I hope that answers your question, Mr. Chair.
It does. Now we'll follow up with question number 2. I wonder if you might speak with the committee about the kinds of factors a judge might take into consideration in deciding whether or not to impose a consecutive or a concurrent sentence.
Mr. Chair, that could be a myriad of things, but you can think about different variables that happen from case to case. Sometimes it's the severity of the case. There may be some certain facts involved in the case that are particularly unique to that particular case that require consecutive sentences. There may be previous compliance issues with this individual on probation, that they struggled on probation, were non-compliant or intentionally non-compliant, that would say, you know, maybe they do need consecutive sentences. There are also situations in which concurrent sentences may be appropriate. You know, sometimes that if there are federal cases involved, and there are certain subsections within the guidelines that talk about, what if I have a federal case that I'm going through and I pick up a state case? In those cases, the court can actually release the offender to the federal case and run that state sentence concurrent. And so that individual would be sent off to federal prison to do their time, and they would actually then be serving state time concurrently. So many of those, again, it's going to depend on, you know, some of the times the uniqueness. If there isn't things that rise to the level of something that would require a departure, for example, sometimes there's aggravated and mitigating factors that the court knows based upon the facts of the case that would potentially warrant, or the past history of the offender, that would warrant consecutive or concurrent sentencings.
Thanks for that. So you have some experience as a prosecutor. I'm guessing that a prosecutor in the circumstance in making decisions about plea negotiations, if there's a hard wall that requires consecutive sentences, that pretty much says it, unless the court's willing essentially to ignore the law, which appears to be going on, at least in some cases. But that might be a bargaining chip for a prosecutor to offer concurrent as opposed to consecutive sentence in some cases to elicit and obtain a plea negotiation on a case. Is that fair to say?
Mr. Chair, yes, it would.
And in terms of departure, you mentioned those. Would you explain to the committee, please, what you mean by a departure sentence?
Yes, sir. The guidelines provides for different types of departures, and what I mean by that is, when we look at the grids themselves, they have those boxes that I've talked with you about, and within those boxes are 3 different months. Those are the middle box is the normal, what you would normally get. If there are certain aggravating factors there, the court can sentence within the box above, and then there's a lower number, which is the court can sentence at that case. If there are certain circumstances in the case that, you know, you see this sometimes in person crimes when, and I think the verbiage is, you know, particularly heinous crimes that are above or outside the norm of this current offense. You know, things like, you know, mutilation of bodies in a homicide case, and or in a child sex case or something of that nature. Something that's outside the norm, there is a provision that allows for aggravating factors, and there are different factors that are non-exclusive that allow for the court to go outside of what that norm grid box is based upon those particular instances. Similarly, Many times there are mitigating factors in the statute as well, and a list of those that potentially could be used to mitigate the offense. And so in that case, there could be a departure downward as far as sentence. There is another type of departure, and that is sometimes used that if an individual, for example, is in a presumptive prison range, there can be a departure motion filed that would allow for the court to depart down to probation as well. So you have a durational departure, and then you have a dispositional departure. So different options for there is a heightened standard there called substantial and compelling reasons. And just as I indicated, the prior conviction was a term of art. Substantial and compelling reasons is a term of art that is used or a standard that's used that the appellate court looks at in determining whether or not there's enough evidence here to substantial and compelling reasons to depart upward or downward.
Thank you, Scott. Question, Representative Smith.
Thank you, Mr. Chair. I don't want to be too hypothetical, so I want to provide a practical application as I understand Section 1 amendment. So I have a family that we've convicted twice. We arrest them a third time, every time for the distribution of prescription medication from their home. And by a family, I mean a mother, father, and son. We get them the third time, we think, well, this has got to do it. They haven't served time yet. We put them in jail. They get out after first appearance on bond, and we buy from them a fourth time. And the suggestion in this amendment would be then, well, the judge could just decide to run the third and fourth violations concurrently. Is that correct? If we were to change that, is that how that might work if he so or she decide? Scott, are you there?
Oh, there we go. I'm sorry, I was having trouble unmuting. Representative Smith, that could be a possibility in your case from the example that you've given. I think, once again, the court would most likely take into a consideration if this was the third or fourth or fifth time that this would actually happen, that most likely concurrent sentences are going to be off the table. But this still does not preclude the ability of the court to actually sentence consecutively. It simply allows for the court the ability to do that under circumstances. And I don't know that the example that you've given, it certainly appears to me that would be ripe for a consecutive sentence.
Yeah, and we could hypothetic the rest of these into what if, and that's not what I'm trying to do, but just trying to get my head around the idea of offering the option of a concurrent sentence for a felony conviction while out on a felony. That one concerns me. The rest of it, I'm still digesting. Thank you, Scott.
Representative Resman.
Thank you, Mr. Chairman. Scott, with Special Rule 10 and Section E, it talks about people that are incarcerated. If someone commits a crime while they're in DOC custody, currently they have to be sentenced consecutively. Is that correct?
That is what the Representative Resman. That is what the statute provides.
So if the law was to change, the judge technically could sentence them to a concurrent?
Not on this particular one. The subsection you were indicating in E, as I have highlighted, would be someone that would actually be in jail, in prison, in an incarcerated capacity. The change that we're asking for is for those individuals that are out on bond, felony bond, not incarcerated.
Committee, other questions? I have none in the room, and I see no hands raised at this point. Scott, I think that's going to do it for you. Thank you very much for your testimony today. Committee, we have the written testimony in support of the bill from the McPherson County Attorney, Amanda Voth, Chief Deputy County Attorney of McPherson County, and I commit that to you for your consideration. I have no other listed proponents. Is there anyone else wishing to testify in support of House Bill 2081? See no one. Is there anyone wishing to provide neutral testimony with regard to House Bill 2081? I see none. And lastly, are there any opponent testimony to House Bill 2081? I have none listed and see none. We will close the hearing then on House Bill 2081, and we'll move on to our second hearing of the afternoon, House Bill 2083. I'll call upon the reviser to inform us of what it purports to do.
Thank you, Mr. Chairman. House Bill 2083 makes changes to the membership of the Kansas Sentencing Commission. So current law in KSA 749102 provides that 4 members of the legislature shall be members of the Sentencing Commission. Those members are appointed by the President of the Senate, the Minority Leader in the Senate, the Speaker of the House, and the Minority Leader in the House. This bill would require that the Senate members be senators who also serve on the Senate Standing Committee on Judiciary, and the House members of the commission would have to be members who also serve on the Standing House Committee on Corrections and Juvenile Justice. Taking questions.
Committee, questions for the reviser? See none. We'll go ahead and begin.
I have a question.
Oh, okay. Sorry, Representative Carmichael. I see your hand now. It's quite large in front of that camera. Surprising.
It looks a lot better like this, doesn't it, Mr. Chair?
That's lovely, lovely. Hand model, I guess.
Got this ring 40 years ago.
There you go. Okay, go ahead with your question.
Ms. Scott, I don't know if you're the right person to ask, but who are the incumbents in these positions presently?
I believe I can answer that. Representative Barker, Representative Heiberger, and then I believe Senator Haley. Is that actually? I'm just going to let Scott answer that.
Scott, can you tell us who the legislative members are of the commission at this point, please?
Yes, and Natalie did a great job. The only other individual is Senator McGinn.
But Senator Haley, is he on it?
Yes, sir.
Okay. Now, as far as I know, Senator McGinn, Representative Barker, and Representative Haley, they're not lawyers. Does that mean they can't serve?
No. In fact, Senator Haley is. I don't believe he's practicing, but
he's not admitted in Kansas. He has a law degree.
no admission to the bar is required as far as legislative members are concerned.
Okay, but the effect would be, I think, at this juncture, to throw Judge Barker off the commission.
That is an interesting characterization, and I'll be happy to talk in my. The answer would be technically yes. But I certainly would be happy to address that more fully in my.
I'll await your testimony. I apologize. Thank you, Mr. Chairman, for your indulgence.
Yes, any other questions for the reviser, Natalie Scott, or her alter ego, Scott Schultz? Okay, we will. Thank you, committee. We will proceed then with the testimony of Scott Schultz, Executive Director of the Kansas Sentencing Commission. Welcome back.
Mr. Chair and members of the committee, thank you so much again, and thank you to the chair for his willingness to have a hearing on the previous bill as well as this one. I will preface this, and I was planning on doing this anyway, but this is an administrative bill that comprises the makeup of the Sentencing Commission, specifically the legislative members. Currently, we have 2 members from the House, 2 members from the Senate. Those are appointed by their parties. So in this instance, Senator McGinn has been appointed by Republican leadership, Senator Haley by Democrat leadership. Similarly, on the House side, Representative Barker has been appointed by Republican leadership, and the House Corrections Zone, Representative Heiberger has been appointed by Democrat leadership. So again, I'm going to preface this with the fact that most of you who know me hopefully know that I'm a straight shooter, and this is by no means any type of political maneuvering or anything of that nature. There is a logical reason, not a political reason, for this particular bill. It stands that as far as current as well as previous members who have served from the legislature on the commission, we have received valuable input from them and continue to do so. And I think that it goes both ways. And I don't want to put words in Representative Heiberger's mouth by any means, but I think that he would probably agree that he has learned quite a bit, much more about the criminal justice system being part of the Sentencing Commission than if he would have just been in a legislative capacity like he is hearing me talk several times a year. In doing so, we're meeting monthly, and so I think that enriches the conversation. One of the reasons why we're some of the few sentencing commissions that actually have legislative members on their commissions. There's many other states that would kill to have legislators on their commissions. So we're very fortunate to do that. This bill simply narrows the funnel, if you will, to individuals that may be more interested in the criminal justice system. Our past experience has been a lot of those individuals that are appointed to the Sentencing Commission originally were on Senate Judiciary or House Corrections or House Judiciary. And as time has gone on, they have been good legislators, they've been reelected, and they've worked their way up in leadership. And so they've taken on more responsibility, which includes chairmanships of other committees, and they've moved on. So what the bill essentially does is it allows for representation from House Corrections and Senate Judiciary on this. And the individuals that I hope that are on this committee as well as Senate Judiciary have a vested interest in criminal justice and public safety, and that they're the right individuals to be not taking away from anything from those individuals that are currently or past serve on the commission. But it seems that this would be those that are interested in serving on those respective committees would have a vested interest in making our criminal justice system better. And that obviously is the aim and some of the mission of the Sentencing Commission. And so we believe that for logical reasons, not political reasons, that this is a good recommendation, and that we'd appreciate your support. And I'd stand for any questions that you might have.
Scott, I wonder if you could, for the benefit of the committee, describe for us the various required members of the commission by category. Maybe, I think you know what I mean. I'm not sure I've said it well, but who do you have on there, and who has to be on there, and what role do they have to serve in order to be subject to appointment?
Certainly. We have 17 members in the commission. Of those individuals, several are appointed by different appointing authorities, whether that be, as I indicated, Republican and Democratic leadership. The Attorney General has either attends or has a designee, Secretary of Corrections, Prisoner Review Board Chair. The Governor appoints several individuals. The Chief Justice will also appoint several judges, of which we have two district court judges and an appellate court judge. So as I've mentioned in the past, we really do have a great cross section of the criminal justice community on the commission, and the legislative members further supplement that because that allows them to have input, because part of our charge is to recommend sentencing reforms to you that will help maintain and make the guidelines better. And so the makeup, as I said, is 17. We have probation, including community corrections and court services. We have two private members or public members that are on the commission as well. And so with that, we receive quite a bit of input. I tell people that we have agendas that everybody brings to the commission, and that's a good thing because then we can vet a lot of things before it gets to you.
Thanks, Scott. It strikes me that the commission brings certainly a number of bills and recommendations annually, and I believe those are as a result of obviously commission discussions. They're not your recommendations. Those are the recommendations of the commission. And one of your charges, of course, is to be watching out for prison population and trying to make sure that we don't have a whole bunch of people in prison that maybe don't need to be there. But I'm curious, in your discussions, does your commission ever talk about public safety at all, or is it just about numbers and keeping prison numbers low?
Mr. Chair, I appreciate that question, and I think that my response would be that the commission actually holds public safety as basically our number one priority. And everything kind of falls in behind after that. Certainly, there are many instances in which the proposals that we have brought to you conform with what the mission of the guidelines are, and that is to make sure that the most serious offenders are taken off the streets and they stay off the streets. And then we look for ways to rehabilitate some of those nonviolent offenders and other offenders that may not be as serious, and look for ways to be able to provide for community support, for other channels and alternatives for them to spend incarcerated. Therefore, or thereby allowing us to reserve prisons for the most serious offenders. So I would say that public safety is always at the top and is at the top. It's not just it's nice to have the data, and that's why we're able to bring the data to you, and it speaks for itself. But the commission is very cognizant of making sure that the Kansas citizens are protected, even despite trying to make these tweaks and changes as far as sentencing and the rest of the system.
I appreciate that. And then one last one. It was a couple of sessions ago when we had this dip and dunk thing going on where we could lock people up in county jails or lock people up in prison again for relatively short periods of time. And the data analysis that was done by the commission on the efficacy of sending people to prison for 90 days revealed, as I recall, a couple of things. It was probably really ineffective in the end. It was disruptive to offenders. It disrupted employment, all kinds of things, and really had little real benefit in terms of reforming behavior. But secondly, that there was quite a disproportionality when it came to what was happening with female offenders versus male offenders. And we changed that law primarily because of the data analysis and the conversations of the Sentencing Commission to bring about equity. So equity seems to me to be also a part of what the commission seeks to achieve in their recommendations. Is that a fair statement?
Mr. Chair, that would be a fair statement.
Representative Smith, then Representative Carmichael.
Thank you, Mr. Chair. Equity or proportionality or along those lines. My question is more along the line, you say there's 17 members, and You all make recommendations, I would suppose, that what bills you would like to bring to this committee. And you do that likely by, I would guess, consensus. Can you tell me what and I'm not asking for individual votes, but on this particular subject matter, what was the concern and what was the vote count, do you recall, to bring this to this committee?
Representative Smith, I could go back and we do have minutes and I could pull that for you. As far as this particular one, I don't recall there being too much consternation on it. Obviously, some of the issues that have been brought forward already, which were, we currently have two of the four currently sitting folks that are not on House Corrections or Senate Judiciary. And so that was a concern, certainly. But that was about the extent of the discussion on this. Just to kind of give you an idea as far as overall, we take feedback from stakeholders, and by stakeholders I mean practitioners, judges, attorneys, folks that are practicing in the field, all year round, and then we put those together as far as from that feedback into recommendations, and that's when we meet with our workshop in September. We go over all those, talk about those things. Many of those things then get fleshed out even farther during the meetings in October, November, even into December, where then we have bills then drafted up and ready to go for the session. And so this was one of those. The commission does raise that, has discussions, and then they vote on it as a body as to whether or not to recommend bringing some of these to you. So we also send a comprehensive letter then as far as proposals to the governor's office, so that the governor's office is aware of those recommendations as well.
I don't think it's any mystery that it would bring a number of questions to probably several of our minds about why this became an important issue for your commission. In that, the folks who are currently on that commission, appointed by the appropriate people, apparently have some background that could be of value. So thank you for that, and if you provide that, I'd appreciate it.
I will do that.
Representative Carmichael.
Mr. Chairman, I apologize. I left my hand up by mistake. I'll express my opinion about this legislation with my vote, should the chair be so inclined as to work this piece of legislation.
Very well. Representative Heiberger.
Thank you, Mr. Chair. I'll just comment that I feel very fortunate to have had the chance to serve on the Sentencing Commission. I think it's really enhanced my ability to be a productive committee member on this committee. And also my service on this committee has made me a more productive member of the Sentencing Commission. And I think it would be great to have another member of this body on the Sentencing Commission. And Scott, with regard to your comment that some sentencing commissions would kill to have legislative members, they would also have the advantage of knowing what the sentence would be for that.
Thank you, committee. Representative Carmichael, your hand is up again. Does that mean you now want to ask a question, or are you still struggling with how to get it down?
It does mean that I want to ask a question.
Carry on.
How do we avoid this legislation being seen as a slap in the face to our speaker? I'll withdraw the question, I'm sorry.
All righty, then let's move on. Any other questions? I don't see any. Scott, I guess in light of, and so that there's some clarity of understanding, understanding your response with Representative Smith would suggest that you would be happy to provide the minutes of the meeting of the commission with respect to this particular recommendation, given you are subject to all the open meetings, business, and that sort of thing?
Yes, Mr. Chair, and I will, as soon as we're done here, I'll be happy to email that link to the committee assistant.
Great, thank you very much. I believe Mr. Schultz is the only proponent testimony. I have no written proponents. I see no listed opponent or neutral. Is there anyone wishing to testify as an opponent or neutral to House Bill 2083? I see none. We'll close the hearing on House Bill 2083 and wish everyone safe travels home and a healthy weekend, and look forward to seeing you Monday when we pick up business at 1:30 in the afternoon. With that, we'll be adjourned.